again. So when did you get out of jail?
The same day, but it's like 10 o'clock at night.
Okay. So how did you pay that bond?
My daughter did.
Okay.
My daughter helped.
Right. So,
and I'm trying to change mine.
You are?
To be my lawyer, yes.
Okay.
When I did everything you told me.
When are you going to be able to get him hired?
He's going to be hired. I'm bringing him his money when I get paid on the 3rd.
On the 3rd of May?
Yes, ma'am.
Okay. So what I'm going to do then, Ms. Delafossi, is reset your case for about 30 days. That should give you more than enough time to get him hired.
Yes.
If you get him hired, bring the reset notice that you get today to him. He'll tell you what you need to do. If for some reason you cannot hire him, then I am ordering you to visit with other attorneys to see if you can try to hire someone, and then we'll see what your options are. Make sure you bring the information about who you've talked to when you come back, so then I know you're trying if it doesn't work out with Mr. Blank. Okay?
Yeah.
Step in front of the clerk. She'll give you a reset notice.
Right away, this judge is signaling something important. Bond conditions aren't just paperwork. Testing positive after release is a red flag in any courtroom. Judges view it as a compliance issue, not just a medical issue. And here's the big question. When someone posts bond, how much responsibility do they really understand they're taking on?
What?
Also, we have all my medical.
Are you under a doctor's care right now?
Yes, ma'am.
Who's your doctor?
I just know her name because she's new. But I go to a licensed clinic on
So this is through December of 22. What about?
My prescriptions.
You still have valid prescriptions for all of these? Okay, so this is from December of 22. Do you have anything that's recent?
I need to fix my prescriptions. And I told them all my prescriptions from the beginning.
So they gave you a printout from J.
This is actually a strategic moment. Resetting the case isn't leniency, it's structure. The judge is creating a timeline that forces accountability. In legal terms, this protects the defendant's right to counsel while making sure the case doesn't drift. Smart courtroom management. But will the defendant follow through?
January of 2022 to December of 2022. So it's just all of last year. So I need.
They didn't give me the one for this year.
No.
Okay, I'm gonna have to go back and explain to you I need the one, my printout of my prescription that I did now recently. Yes.
What are you being treated for? What are you being treated for?
Bipolar, schizophrenia, manic depression, and anxiety and insomnia. Because I have blood transfusion, and I have 2 broken discs in my back, and I have 3 in my foot. I have pinched nerves and torn ligaments in my foot because I had fell down.
Now the courtroom tone shifts. We're no longer talking about paperwork. We're talking about medical explanations. Judges hear these claims all the time, but what matters is documentation and consistency. The emotional stakes rise here because credibility is everything. Do you think the judge is buying this explanation?
My daughter is helping her, and I have all my medical records showing that.
So here's my.
If you don't mind.
No, just hang on a second. Let me just explain what my concern is, did you drive here? How did you get here today?
My cousin.
Do you drive?
Yes, ma'am.
Okay. The problem is even if you have all of these prescriptions, the concern is that you seem to be under the influence to a point that makes me concerned about you possibly.
This is the turning point. Even prescribed medication can become a legal concern if it appears to impair judgment or safety, especially driving. The judge isn't accusing, they're assessing risk. And courts prioritize public safety above all else. That's where legal discretion kicks in hard.
That's why I had this, because my doctor knows I don't do drugs. I only take my prescriptions, and it was MDMA that was switched on me.
When?
Those medical records. That's why the doctor gave me this right here.
Let me see what you're talking
And
about.
I don't know how long she had been doing that to me.
Who do you think was
My daddy's first wife, because she felt like my daddy took her, my mom took her husband, and she just been mistreating all of his kids with my mom. And I have a big heart. I was there for her.
Listen closely. The judge is connecting patterns, not just individual test results. Multiple substances, even prescribed ones, raise questions about management and control. In court, perception matters almost as much as proof. Once concern is established, restrictions are often inevitable.
Because my sister, her daughter died, which was my sister. I was there for her.
So this is a test that you took, a drug test back in October of last year. Okay.
Yeah.
Well, I don't understand. Okay. Well, I mean, again, the concern is that you're testing positive for, even if it's prescribed, hydrocodone, morphine, norhydrocodone. I mean, this isn't just one type of pain pill. There's obviously an issue going on here that is not necessarily related to coding.
And there it is, a sweeping bond condition, no driving. That's a powerful example of judicial authority in action. It's preventative, not punitive. The judge is essentially saying, safety first, explanations later. The big takeaway? Court compliance isn't optional. It shapes every decision moving forward.